Good morning, everyone. Welcome to the Board of Registered Nursing Board meeting. Today is March 20th, 2025. We will now take roll call to establish our quorum. My name is Dolores Trujillo, and I have been appointed by Governor Newsom to the role of the Direct Care Provider, and I am the current president of the board. Board Member Jovita Dominguez.
Good morning, Jovita Dominguez, appointed by Governor Newsom in the Education and Licensing.
Thank you. Board Member Patricia Nguyen.
Good morning, everyone. Tricia Nguyen. I've been appointed by Governor Newsom in the public member role.
Thank you. Board Member David Lawler.
Good morning, David Lawler, appointed by Governor Newsom in a public member role.
And Board Member Allison Cormack.
Good morning. My name is Allison Cormack. I was appointed by the Speaker of the Assembly in a public member role.
Thank you. The board's executive officer, Loretta Melby.
Morning, I'm Loretta Lori Melby, and I'm the board's executive officer appointed by the board.
Thank you, Lori. And our board counsel, Reza Pejjuhesh.
Good morning, Reza Pejjuhesh, Board Legal Counsel.
Thank you. Our quorum has been established. We will now move to the next item on the agenda. Item 2.0, this is a general instructions for the format of a teleconference call. BRN moderator, take it away.
Good morning. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the board reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate that they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and will announce that your time has exceeded the time allotted. I will then proceed to the next member of the public who has a comment. I will also query the in-person location, BRNHQ, for any public requests for comments there in person. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. When your turn comes, you will be prompted to unmute. If your question can be answered, the board will respond accordingly. When making your comment, speak about anything you believe is important for the members to know. Remember, board members cannot address any item not on the agenda. Items not on the agenda, items not on the agenda at that moment, items that you would like to add to a future meeting, or items that will be discussed later on in the agenda will be discussed at their correct times during the meeting. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when board members or BRN staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will mute your microphone automatically.
Thank you. We'll move on to item 3.0. This is public comment for items not on the agenda and items for future agenda. BRN moderator.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Bianca Stepani would like to make a comment. 1 second, please.
Of the board. My name is Bianca Stopani, and I have reported to RNs who have engaged in substance abuse and do suffer from mental illnesses. And unfortunately, the reports have been closed. One of them is still operating with her RN license. And I did make a public comment at the previous meeting, the Nurse and Midwifery Committee. And Ms. Melby actually made a comment after my comment stating that whenever the nurses are up for renewing their license, they are simply asked if they struggle with substance abuse or mental illness to report it. However, please keep in mind that these individuals struggling with substance abuse or mental illness are not even in the clear state of mind to accept or request the help. Therefore, it is imperative that the enforcement board actually does their due diligence and conducts a thorough investigation by calling for a random drug test as well as a psychological evaluation, not only when the complaints are submitted, but also when they're up for renewing their license. At this point, I am prepared to even speak with local legislators to see if they can draft a bill to implement some sort of accountability for all the boards, not just the nursing board, to make sure that the public is safe and that the RNs are operating from a place of integrity. Thank you very much.
So that our board members are aware to provide some clarity on that comment. This person did make a public comment about this in a previous meeting, and I informed them that we have no requirement for drug testing for licensure or renewal of licensure. We do receive complaints. Complaints, when they're received, go through the same exact process. They get intaked and triage and investigation, and then there is an outcome. I don't have any control of that outcome. In fact, I'm removed from it completely. And so if drug testing was something that was going to be added to the licensing process, it would have to go through a legislative ask, because that is not a current requirement that we have right now.
Thank you for your comment. Do we have any public requests for comments there in person in the BRN HQ?
Yes, we have one request for public comment here.
And this is for items not on the agenda today.
Good morning, and thank you for your time. Oh, I got to push buttons. Sorry. I just do anesthesia. I don't do this part. Sorry. So good morning, and thank you for your time. My name is Emily Frank. I am a CRNA, a member of the public, and I'm here on behalf of the California Association of Nurse Anesthesiology. We're here to urge the Board of Registered Nursing to support our bill, AB 1215. Not on the agenda. A bill that ensures nurse anesthetists, nurse practitioners, and nurse midwives can serve on hospital medical staffs. The issue directly impacts patient safety, healthcare access, and professional recognition of advanced practice nurses, all of which align with the BRN's mission to protect the public, promote access to care, and advance the nursing profession. For 2 years, CANA has petitioned CDPH to update outdated regulations that limit hospital medical staff membership to physicians, dentists, podiatrists, and clinical psychologists, excluding high-qualified advanced practice nurses. These restrictions are not only outdated, but conflict with existing law. The California Business and Profession Code already allows hospitals to grant medical staff membership to licensed, competent, and ethical providers. A 1990 California Attorney General opinion confirmed that CDPH's restrictions lacked legal support. Yet hospitals hesitate to act out of fear of regulatory enforcement. Why does this matter? In at least 4 rural counties in California, nurse anesthetists are the sole anesthesia providers. Yet without medical staff membership, they are excluded from critical hospital decision-making, including credentialing, policy development, and patient care oversight. This creates unnecessary barriers to safe, efficient anesthesia services. Since CDPH refuses to remove these unlawful restrictions, AB 1215 is necessary to ensure hospitals can recognize the full leadership role of advanced practice nurses. We urge the BRN to support this bill by 1, placing this issue on a future agenda, 2, taking an official position in favor of AB 1215, and 3, advocating for the rightful inclusion of nurse anesthetists and other APRNs on hospital medical staffs. This is an opportunity for the BRN to stand by its mission and help eliminate barriers that limit patient access to care, and we ask for your support. Thank you.
Sorry about that.
Thank you for your comment. Do we have any more in person?
Board moderator, it looks like there was a bunch of people that jumped into public comment.
Right, I'm going to go back to that. I
Yeah,
just want
there's
to
no
make
more
sure
in
I wanted to
person.
see. Okay, perfect. Thank you. Thomas would like to make a comment. 1 second, please. Oh, Thomas changed his mind. I'm sorry. Joshua Kemper would like to make a comment. 1 second, please.
Hey, good morning, esteemed members of the board. Thank you for the opportunity to speak. My name is Joshua Kemper, Doctor of Nursing Practice and CRNA, also known as nurse anesthesiologist. I provide anesthesia at hospitals and surgery centers in Visalia, California, in the Central Valley. I provided independent direct patient care since 2015, yet I have no voting rights on hospital medical staffs. And I'd like to urge the BRN to support Assembly Bill 1215 because it modernizes outdated Title 22 regulations to better align with existing California law that ensures that ensuring that nurse anesthesiologists and other APRNs can be recognized in hospital governance. California law already allows independent CRNA practice, but these outdated Title 22 regulations exclude CRNAs from medical staff membership, even when they're the sole anesthesia providers, as mentioned before, in 4 different counties. Some administrators have been misled into thinking that CRNAs, quote, must be supervised or, quote, can't serve on medical staffs despite California law permitting full medical staff membership. Apparently for nurse practitioners under Business and Profession Code Section 805.5. California Department of Public Health has ignored this issue for over 30 years since the DHS's opinion, those issued in 1990, was upheld and affirmed by Attorney General John Van de Kamp in opinion number 90-0612, confirming that Title 22's restrictions on non-physician medical staff membership were in fact unlawful. This harms patients by delaying care and provides for inconsistent credentialing that leaves hospital staff and administrators with regulatory uncertainty in situations like what unfolded in Modesto in 2024. If this bill had been in place, hospital bylaws would likely have been updated to reflect state law, reducing credentialing delays that would have no longer been based on outdated Title 22 language. Assembly Bill 1215 does not dictate any staffing models in any way, but it does remove any legal uncertainty that leads to last-minute administrative barriers like what happened in Modesto. I'd like to again urge the BRN to update Title 22 to match existing state law, prevent outdated bylaws from delaying care, and ensure that all anesthesia providers have input.
Thank you for your comment. You've exceeded your time allotted. Deborah Varela would like to make a comment. 1 second, please.
Very much to the board for the opportunity to speak. My name is Deborah Varela. I also am a CRNA and have been for 34 years. Emily and Thomas have, I feel like, really well covered 1215, the logistics to it. So if I may, I'd like to put sort of a real life personal experience to this. I am currently employed at the Modesto facility that was involved this past summer in interruption of care. And I would just like to emphasize that AB 1215 Of course, does not change our scope of practice, but would allow us opportunity to be involved at a level that could protect our patients from such a disruption, our facilities, our physicians, and the nurses. All of these people had also interruption in their work that they do to ensure patient care and access. Consequences have resulted in decreased ability to recruit CRNAs to an area that's already underserved. We have been not allowed a position on the medical staff where, again, I think that we could be instrumental in seeing that in the future we don't have disruption to a population that's already vulnerable and short of care. We're proud of the work we do and would greatly appreciate the support with AB 1215 so that we can ensure moving forward patient access is here for our patients. Thank you again for your time.
Thank you for your comment. Gina Yen would like to make a comment. 1 second, please.
To this layout for web meetings.
Gina, go ahead.
Thank you. Thank you so much, ladies and gentlemen, members of the board, for allowing me to speak. My name is Gina Yan. I am a CRNA. I'm currently practicing at Kern Medical Center in Bakersfield, California. My group is consisted of 25 CRNAs and 4 anesthesiologists. We all practice independently alongside each other to provide anesthesia services to surgical and obstetric patient populations at this level 2 trauma center and its associated outpatient surgery center. This is the only trauma center in the surrounding area and a safety net hospital for the surrounding populations. In 2024 last year, my colleagues and I administered about 6,000 anesthetics in the operating rooms and procedure areas, as well as 2,000 anesthetic service procedures in the obstetric services. About 90% of those anesthetics are administered by my CRNA colleagues and myself in the independent practice setting, as well as all of the obstetric services, including epidurals and C-sections. I am here to urge the board to support AB 876. It's a crucial bill that safeguards the patient access to anesthesia care in the critical areas such as where I work myself by reinforcing the long-established practice of CRNAs in California. Like many have spoken to regarding the incident at Modesto Hospital last year, over 1,000 surgeries were canceled or delayed due to the interference from CDPH. Where I work, these are very vulnerable patient populations, and at these safety net hospitals, they do not have a lot of options in regards to access to anesthesia care. I truly believe that AB 876 is crucial for CRNA's practice in California because it eliminates unnecessary regulations and codifies and solidifies the longstanding practice that CRNA has established in the state. Thank you so much for your time.
Board moderator, just a reminder, AB 876 is on our agenda, so we will not be taking any more public comment related to that bill until bill is discussed later on in the agenda. If public commenters still want to make a comment about 1215 that is not on the agenda, they are welcome to. However, I do want to let them know that it is scheduled to be on the May agenda, and they as the board members today cannot take any motion of support or against or anything today, they are welcome to continue to make public comment today, or they can hold their public comment where the board can actually take action on it, and that would be at the May board meeting. But at this point, we will not be taking any further public comment on 876, please.
Dr. Kristen Roman would like to make a comment. 1 second, please. Dr. Roman, on your phone, it's *6 or #6. And we'll come back to Dr. Roman. Sharon French would like to make a comment. 1 second, please.
Hi, for your time.
Oh,
Hi.
sorry. Is this Dr. Roman?
No, this is Sharon French.
Sharon French. Oh, okay. I'm sorry. It didn't update on my side. Okay, go ahead. I'm sorry.
Did it. I won't reiterate everything people have said so far. I just want to thank the board for considering the bills from the CRNA organization with California, with CANA. I'll hold my comment until the May for 12:15, but look forward to discussing 876 when it comes up on the agenda. Thank you.
Thank you for your comment. Jake Sarurek would like to make a comment. 1 second, please.
Okay.
Yes, go ahead. I'm sorry.
Hi there. I work with Debbie, and I again would like to ask the board to put the AB 876 and AB 1215 on the agenda. I know how we are affected by our role not being clearly defined, and also not having the voting right on the medical staff can affect our role and ability to practice too. And thank you very much.
Thank you for your comment.
And just for clarification, 876 is on our agenda today, and 12:15 will be on the May agenda.
Julia Harris would like to make a comment. 1 second, please. Julia, on your computer, if you have Windows open, there will be a small box probably behind them that you'll have to click that says unmute me. And I'll come back to Julia. Ashley Banks would like to make a comment. 1 second, please. Ashley, go ahead.
Good morning, everyone. I wanted to thank the board for hearing our comments. My name is Ashley Banks, and I'm a nurse anesthesia resident in Fresno, California. And I'm here today to voice my strong support for AB 1215, which would allow advanced practice providers like nurse anesthetists to be fully recognized as members of hospital staff. This bill would ensure that hospitals can function as truly interdisciplinary teams where all qualified professionals have a seat at the table and can advocate for the best patient-centered care. Thank you so much.
Thank you for your comment. I'm going to try to go back to Julia again. Julia, on your computer, when I unmute you, a small box will pop open that says unmute me. And if you have windows open on your computer, you will have to minimize them because it's more than likely behind it.
You hear me now?
There you go.
Oh, great. Thank you so much. So good morning, members of the Board of Registered Nursing. My name is Julia Harris, and I urge your support for AB 1215, a critical bill that enhances patient safety by ensuring nurse anesthesiologists are included in hospital medical staff governance. This bill is not about professional recognition, is about protecting public access to safe, uninterrupted anesthesia care. I have worked in hospitals where nurse anesthesiologists were the only anesthesia providers, yet outdated regulations exclude us from hospital decision-making. This creates barriers that delay credentialing, disrupt services, and impacts patient care. In 2024, nearly 1,000 surgeries were canceled, as several of these other speakers have noted. And it was because hospital bylaws fails to recognize CRNAs disproportionately, which disproportionately affected Medi-Cal and Medicare patients. AB 1215 prevents this from happening again by allowing hospitals to formally include CRNAs in governance, ensuring anesthesia services remain accessible, and ensures that the practice within the hospital matches what the bylaws of the hospital allows. CRNAs undergo rigorous education and training with outcomes equal to physician anesthesiologists. However, without representation in governments, key safety policies and workforce decisions are made without input from those delivering the anesthesia care. This is especially dangerous in rural and underserved areas where CRNAs often are the only providers ensuring access to surgical and obstetric care. California hospitals already include other advanced practice nurses in governance, yet CRNAs remain excluded. AB 1215 modernizes outdated regulations, ensuring hospitals recognition the professional safeguarding patient lives daily. I respectfully urge the Board of Registered Nursing to support AB 1215 and help protect access to safe anesthesia care. Thank you so much.
Thank you for your comment.
Board moderator, before we move on to the next one, just so that I could reiterate for maybe those that weren't on earlier, just because I've seen our participant list grow. The board cannot support a bill that is not on the agenda. 1215 is not on our agenda today. It will be added to the May agenda. So if participants want to hold off to the May board meeting and save their public comment till then, when the board can take a position on it, that is an option. However, we are willing to continue to hear public comment today as it's not on the agenda. But I want the people to know that the board can take no action on this bill today as it is not on the agenda. The board will take action on this bill in the May board meeting, so you may consider waiting until May.
Thank you. Dr. Kristen Roman, I know it's regarding AB 1215, but would you like to make a comment? And again, on your computer, if you have Windows open, you have to minimize and look for the small box that says unmute me. There you go.
Hey, you should be able to hear me now.
Yes, you're fine.
Excellent. Thank you so much. I am calling in regard to AB 1215. I know it'll be on the May agenda, but I figure let's get the ball rolling now. My name is Kristen Roman. I'm writing in support of AB 15. I presently work in a hospital with an ACT full supervision model. CRNAs and advanced practice nurses provide core services at this hospital, yet we're not allowed to join the medical staff, which is solely physician-led. And this form of exclusionary leadership is outdated and does not reflect the reality of today's healthcare system. Business and Professions Code allows nurse practitioners to serve on hospital medical staffs, yet the CDPH has not updated its regulations to reflect these changes. On numerous occasions, the CDPH has ignored petitions to rectify this discrepancy and update their restrictive regulations. There's even an Attorney General opinion which confirms that these restrictions enforced by the CDPH are not supported by law. Yet the CDPH remains steadfast in its refusal to update its regulations. AB 1215 will put a stop to this roadblock by putting in statute what CDPH refuses to update in regulations. Rural counties served primarily by nurse anesthesia providers are unable to update anesthesia credentialing and policies because there's no anesthesia input on the hospital staff. This is a major problem. Healthcare facilities must be able to update policies and facility bylaws to reflect their practice needs to ensure safe care delivery to their patients. An inability to ensure that practice and safety needs match hospital bylaws puts a facility at risk of facing CDPH sanctions and can greatly limit the care a hospital can provide to its community. I encourage the BRN to consider the importance of AB 1215 in their future discussions. It was shocking to me that this issue is not already on the BRN agenda for this meeting of legislative issues to consider today. This issue is critical not only to APRNs, but most importantly to our patients who deserve safe, timely, and accessible care no matter where they live or how they pay for services. Thank you for the time and commitment to protecting and advancing nurse practice in California. Thank you.
Thank you for your comment. Nancy Smith would like to make a comment. A second, please.
My comment. I think my question is, given how important this issue is, that everyone has been talking about, I just wonder how we prioritize the bills that go on the agenda to talk about, because we've been talking so much in enforcement and discipline, and in the committee meetings that just went a few days ago, we were talking about the actual numbers with advanced practice nurses. And since 2018, I believe, just going from memory, I think there were like 419 advanced practice, like NPs total disciplined of all discipline, and 42% of them gave up or revoked or surrendered their licenses right away. And so that's half of the advanced practice nurses are already giving up their licenses. So I feel like if you're getting disciplined, you're not going back to practice. So why don't we put our efforts more towards this bill that is far more about protecting the health, safety, and well-being of the public through fair and consistent application of the statutes and regulations governing nursing practice and education in California? Because we have had very inconsistent interpretation of the regulations, I feel, in the Board of Nursing. And I feel like we're putting a lot of time and effort towards just a lot of enforcement and discipline challenges where this is really important. And I'm just wondering, how do we prioritize the bills that we look into? Thank you.
I can address this bill quickly. This bill 1215 does not affect the Nurse Practice Act. And the Board of Registered Nursing comes under the Nurse Practice Act. Therefore, the bills that we typically put on our agenda are bills that specifically talk to the Nurse Practice Act. And when there are bills that affect nurse practice that aren't directly under the jurisdiction of the Board of Registered Nursing, sometimes those bills are left off agendas. Sometimes our board will take a watch position because they really don't have authority over that. And others times we will put them on the agenda to have a discussion around it and take a position. But most of the bills that we put onto the agenda and take positions on directly affect the Nurse Practice Act. And those are the ones that we typically tend to take action on.
Thank you for your comment. Thank you. Robert Agat would like to make a comment. 1 second, please. Agat, sorry.
Hi, am I unmuted?
Yes, no, go ahead.
All right, great, thank you. Good afternoon, my name is Robert Augett. I've served for the past 5 years as the sole anesthesia provider at Mountains Community Hospital, which is a remote critical access hospital in the San Bernardino Mountains. A few months ago, I stepped out of a Med-Exec committee meeting where critical decisions like crafting policies to address post-op complications and Bader Heart Committee initiatives were deferred. Why? Because under current regulations, I'm barred from participating in closed session forums, even though I develop anesthesia policies and review cases daily for our hospital. Across California, these outdated regulations are forcing rural facilities to delay care and strain already limited resources. This isn't about scope creep as the objection comes up. It's about patient safety and common sense. CRNAs like myself are often the only anesthesia providers in rural counties, yet we're excluded from medical staff decisions that directly impact the anesthesia care we deliver. Let me be clear, physicians are our partners, but when my colleague told me last week, I've got a 3-hour committee meeting, you're lucky you get to go home, it underscored a systemic problem. We've practiced competently for over 100 years in California and should not only share governance responsibilities, but be held to the same level of scrutiny as our colleagues that have official med staff membership allowed. Modernizing these statutes isn't just about workload, though. It's about ensuring that people who travel to live or vacation in rural areas aren't left behind. The reality is, as much as some may wish that a physician anesthesiologist be available at all rural hospitals, the fact is that this is just not possible, as they well know themselves. There simply aren't enough anesthesia providers available to fill the need and demand at all facilities. When you travel for vacation to rural areas to go skiing, hiking, camping, and you break your leg, it is almost certain that your anesthesia will be provided by an independently practicing CRNA at the hospital you're transported to. I think you would agree you'd want the facility expert in all matters related to anesthesia to have strong input regarding the anesthesia policies instead of what currently happens, which is namely anesthesia policies being crafted by, as much as I like them, the podiatrist, the pediatrician, or the resident psychologist. This really is a no-brainer. So let's pass these bills to strengthen interdisciplinary collaboration, preserves physician leadership.
Board moderator, if you're speaking, we're not able to hear you.
Sorry. Robert, thank you for your comment. You have exceeded your time allotted. Board President Trujillo, if there are there any other in-person requests for comments?
There are no other requests for comments here.
Thank you. There are no other requests for comments on the WebEx. Would you like me to close this window?
Yes, please. Thank you.
Thank you.
All right, moving on to item 4.0. This is the report on legislation. And we have Marissa Clark that will take this.
Good morning. Thank you. Marissa Clark, Chief of Legislative Affairs. Before I jump in, I just want to piggyback a little off what Lori said, if that's okay, around what bills go on the agenda, and just clarify that it's 100% correct, the Nursing Practice Act, as well as broadly the board's jurisdiction. And this is not a very clean and tightly defined thing. So it's something we're constantly kind of trying to massage and figure out what does it make sense for us to weigh in on. So broadly, we try and look at, does it impact the Nurse Practice Act proper? That is obviously the cleanest, easiest one, or board operations in general. Like you'll notice on today's agenda, we have a handful of bills that impact all the boards under DCA. Or maybe is there something that would impact our processes, which one of the bills doesn't touch the Nurse Practice Act, but its implications could check our processes. And so we are always open to listening to bills that people think we should bring up, and we'll give them consideration. Typically, historically, when it comes to staffing stuff, because that is not under our jurisdiction and facilities aren't under our jurisdiction, usually we don't lean towards those. However, there could always be overlaps and nexuses that we're not seeing. So that, if that helps kind of provide clarification that it's the Nurse Practice Act, but just the board's kind of authority and ability to, implement or how it would affect us is where we try and narrow it so that we're not overreaching into other areas. But again, always happy to second look at bills if people think there is really a nexus there that we should weigh in on. So, all right. So the first bill on the agenda is Assembly Bill 667 by Assemblymember Salash. And this bill proposes requirements both for the California Department of Public Health as well as all the boards under DCA. But for the purposes of this discussion and the bill analysis, I'm just focusing on the requirements that impact the boards under DCA, since that would obviously impact the BRN. So the bill would establish the following definitions: board, any board under the jurisdiction of Department of Consumer Affairs, and interpreter, which would mean any individual who satisfies all of the following conditions: is fluent in English and in the preferred language of the applicant, has not acted as an interpreter for the examination within the year preceding the date of the examination, is not licensed and has not been issued the license for which the applicant is taking the examination, is not a current or former student in an educational program for the license for which the applicant is taking the examination, and is not a current or former student in an apprenticeship or training program for the license for which the applicant is taking the examination. And lastly, is not a current or former owner or employee of a school for the license for which the applicant is taking the examination. So those are all the qualifiers for the term interpreter. So largely, this bill would require each board under DCA beginning July 1, 2026 to do all of the following: Permit an applicant who cannot read, speak, or write in English to use an interpreter at no cost to the applicant to interpret the English verbal and oral portions of a state-administered or contracted license examination to their preferred language, provided the applicant meets all other requirements for licensure. It would also require every board to post on their website that an applicant may use an interpreter to interpret a license examination if the applicant cannot read, speak, or write in English. Provided the applicant meets all of the other competency requirements for licensure, the notice shall be posted in English, Spanish, Farsi, Hindi, Chinese, Cantonese, Mandarin, Korean, Vietnamese, Tagalog, and Arabic. And then it will include a section in, the boards have to include a section in their license applications that asks an applicant to identify their preferred written, spoken, and signed languages. The bill would require each board under the Department of Consumer Affairs beginning July 1, 2027, to conduct an annual review of the language preferences of applicants that is collected from those license applications. The bill would require each board beginning January 1, 2029 to annually report to the Senate Business Professions and Economic Development and the Assembly Business and Professions Committees on language preference data collected from those license applications. And lastly, the bill would sunset its provisions on January 1, 2033. So just a couple points for additional consideration or context that were included in the analysis. One, kind of touching on what licensing exam this would mean for the board, and that is the NCLEX. That is the National Council Licensure Examination. And that is a nationwide examination for licensing of nurses in United States, Canada, and Australia. And so the NCLEX is actually developed and owned by the National Council on State Boards of Nursing, or NCSBN. And then NCSBN contracts with a company called Pearson VUE, who administers the test through their network of Pearson VUE professional centers throughout the country. So currently, from a logistical standpoint, the board doesn't have a role in administering the NCLEX. Additionally, one point in there around the eligibility for an interpreter that we thought was important to note, that it would prohibit an interpreter from having or being either having the license or being in school to acquire the same license that the applicant is seeking, which means the interpreter could not be a practicing RN or a nursing student. And it totally makes sense why this would be included. I think from a fairness is the intention there, to try and make sure there's no one up, but it does potentially kind of raise the concerns around terminology and phrases using in nursing practice being very complex. I can speak as a non-nurse that I often have the difficult times, again, having worked in this field now for years, speaking and pronouncing some of those, and I'm sure not all of them have a very clean translation. So it does potentially could lead to maybe inequitable kind of access for that applicant if their interpreter isn't familiar with the terminology and therefore can't provide an accurate translation. So those were just the points I wanted to highlight. Happy to answer any questions.
Board Member Patricia Nguyen.
Thank you very much. I like the intent behind this bill, but it seems to me to have 11 different languages where interpreters would have to be available at no cost to the applicant, which means they'd have to be somehow retained by the department or by the board. It just could be an extremely costly requirement. So I would like to just keep track of that as we move forward.
So just for kind of clarification, because this is offered by Pearson VUE is worldwide. And so there are various test centers located throughout California, located throughout the states, located in Canada, et cetera. And a student who has graduated nursing school goes to that location to do it. We do not administer anything here at all. And so we couldn't even retain people to be able to do this. It would be through Pearson VUE. So we would have to update the contract to require NCSBN and Pearson VUE to have a interpreter available for our particular applicants. That could potentially end up looking like an accommodations kind of request. We do special accommodations for people that have ADA issues or any needs that need to be addressed to facilitate that. That is a possibility. But what I want to share is NCSBN, when they had to translate from English to French, it was a couple-year process to do it. And what they have to do is it's a computerized adaptive test. And so depending on how you answer one question depends on what question you get next. So there is no preparation that says 1 through 20 are the questions you're going to get. And to be honest, there's thousands of questions. And so you would have to have a person physically there, or by like a telephone, Lexicom, something to that effect, to do the translation. But like what we saw with AB 890, they mentioned the use of the term enfermera especializada, and that is specialized nurse in English. It was intended to mean nurse practitioner, but we learned through public comment that there is no such direct translation to nurse practitioner, in Mexico. So there could be terms like that throughout the NCLEX that actually do not even have a direct translation, and therefore it wouldn't be an accurate, validated test that would be able to be done. So I looked up what NCSBN did to translate the NCLEX to French. And so what they have on their website is, it said they did a 5-step model below. Only approved items move forward in each step. Step 1, to begin, only approved NCLEX item which have passed the rigorous NCLEX item development process are selected for translation. 2, a review panel of the Canadian nurses is gathered to further review the selected items for accuracy, currency, and entry-level appropriateness. Step 3, an approved vendor with reputable expertise in exam translation is selected. The vendor translate approved items from English to Canadian French. For the purpose of the translation consistency, a lexicon is used and is continually updated during the process. Efforts are placed to ensure items reflect language and cultural understandings in the intended examinee. Step 4, a panel of 3 to 6 Canadian nurses with Canadian French English proficiency is selected to perform further review. These practicing nurses in Francophone speaking organizations review the translated items using various methods. The focus of the NCLEX translation review panel is assessment of the language and contextual principles to ensure the translation is equivalent to the original item. And then it goes on that the translation RNs shall meet the below qualifications, and they do require them to be an RN. They do require them to have many of the items that are actually excluded from this. And then step 5, translated items used during NCLEX administration are regularly monitored for changes in item analysis data. After receiving adequate data, the items are subjected to differential item functioning DIF analysis. This analysis and subsequent reviews seek to detect items with unintended bias to the candidate population. And it says, while eliminating unintended bias, the exam measures 1, construct the minimum knowledge, skills, and abilities required to practice safe and effective entry-level nursing. Last year, Marissa and I were on a call with NCSBN to kind of discuss if this was possible to offer additional translations. And they said, no, not at this time, because of the complexity of it and the way that the exam is written and delivered. But it is something that they're looking at. And one of the items that was brought up by Marissa when she talked about a student not being able to do it, I actually very much agree with that, because that student will hopefully graduate and have to take that NCLEX, and you don't want them translating that NCLEX 500 times, getting some kind of sneak peeks in it that could cause an issue with whether the validity of the delivery of that test for that person. So great intent, but I don't believe, when I'm looking at it from just a kind of if this is implementable, I don't think that we have ability to implement that at this point.
Board. Sorry. Oh, okay. Go ahead.
This is Board Member Cormack. Thank you, Ms. Clark. So, the NCLEX is really the foundation of everything in licensing, and this bill and the analysis is a good reminder of the effort that goes into making it accurate, consistent, equitable, up-to-date, et cetera. It's significant. So I just want to start with that. Second, you know, I did have a job once where we worked with translators, and being a translator, which of course is different from being an interpreter, is a real specialty area, especially in something that has clear terminology. So looking at like step 3 of what NCSBN goes through to make sure that it works in Canadian French, right, which is different than, you know, French, and probably different than French that's spoken in other places in the world, like, you know, Africa and Polynesia, et cetera. So I just want to emphasize that, you know, you can really make mistakes in other languages unless you're deeply familiar with it, including from a cultural perspective. So it makes, to me, more sense to focus on the test and less on an interpreter for someone taking the test. I guess for me, the logical next question in this state would be if we were, you know, not we, if one were to choose another language, it seems like that would probably be Spanish. So I guess that's one thing as, you know, collectively, the legislature looks at this and thinks about what would make the most sense in California. I assume those numbers are correct. And then just one teeny tiny question. I'm familiar with Cantonese and Mandarin as the main parts of Chinese. So when the author says Chinese, what is they list Chinese, Cantonese, and Mandarin. So I'm not quite sure what they mean by that.
That is a good question. I don't have the answer at this moment.
Okay, it's fine. It's just, you know, I know there are many dialects and Mandarin, and I don't think that's correct. I think there are many languages that we consider Chinese. So Mandarin and Cantonese, I think, are different. I don't know what they mean by the third one. So always interesting to learn, like how complicated things are, isn't it? So thank you.
Any other questions or comments from board members? All right, I would like to make a motion. I believe in the intent of this bill. And so I would like to make a motion to watch it, actually.
I'll second that. Oh, go ahead. Sorry. I was too quick.
If this bill passes, we were not able to implement it. So what I would ask is for a call out potentially to exclude the BRN from this, because there's no way that we can implement this the way that it's written.
So would we put that in the motion?
It would be a motion. Marissa?
Yeah, again, depending on where the board lands, it could be, if you're requesting amendments, typically your most common are going to be either a support if amended. However, the assumption there is if the amendments aren't taken, then the board defaults to a neutral, or an oppose unless amended, which assumes if the amendments aren't taken, you default to an oppose.
Yeah.
You know, the problem is it's not really enforceable, and it's
Yeah.
especially not enforceable on this timeline where, you know, everything would have to be done by July 1st, 2027, and they did one language in more than 2 years. So yeah, probably.
All right, I would like to, did you have some?
I was just going to ask interrupt with a procedural question. Are we going to handle each bill and then turn to public comment for all of the bills? Or
I'm looking at
proceed to public comment
after each bill.
Okay. So in that case, you may or may not get some insight from public comment on motion you want to make.
All right, before we make a motion, BRN moderator will open it up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for a comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." President Trujillo, there are no public requests for comments on the WebEx. Do we have any in-person requests for comments there in BRN HQ?
No, it doesn't appear we have any requests for comment here.
Thank you. Would you like me to close this window?
Thank you. So I'd like to revise the original motion that I did not complete anyway. I would like to make a motion to oppose unless amended. You want to finish?
I second David Lawler.
And that amended area would be,
I was going to ask it, what could they do? What kinds of amendments could they take to make it enforceable? And it's kind of hard for me to imagine what that would be.
We would have to ask for us to be excluded from the bill. It would be a call out for BRN to not be part of the bill. That would be what your ask would be. That way this bill could go ahead for other DCA boards that are able to implement it, but BRN, due to us not being able to implement it, would be called out so that if this bill passes, which probably it would, we would not have to implement it at the BRN.
It is a DCA wide, so all the boards currently under Department of Consumer Affairs would be held to this. I know they're each looking at it individually. You know, all of our exams and tests are completely different, which is one of the hardest reasons why doing all department bills are. But as Lori said, if it were to just remove us, that way we wouldn't inhibit. If there are boards who are able to implement this, that's great. But it would kind of take us out of it.
so that way, I guess if NCSBN did move with this bill, we can assist them.
This bill doesn't affect NCSBN.
Okay.
We are all, so NCSBN, we're contracted with NCSBN and we're constantly working with them. And like I shared in the earlier conversation, Marissa and I even met with them last year to see what the process was to expand the languages with offering NCLEX. They're always looking at that. That's something that they're doing, but we are limited by what they choose on a business side and what kind of resources they have on whether they translate and how many they translate. So that is not something that we have control over, but we can continue to work with NCSBN and just say, hey, there's a need and have those conversations. That doesn't need to be part of the motion or the bill.
Can you do the call out phrase again and I can say so moved?
Yeah, so it would be oppose unless amended, and the amendment requested would be to exclude the Board of Registered Nursing from having to implement this at this point.
And I so move. We have a second from David Lawler. So we went to public comment, so we can take this to a vote. Dolores Trujillo votes yes. Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen.
Nguyen, yes.
Board Member David Lawler.
Lawler, yes.
And Board Member Allison Cormack.
Cormack, yes.
Thank you.
Okay, so the next bill is Assembly Bill 742. And just some quick background on current law as it relates to the processes in this bill. Current law requires all boards under the Department of Consumer Affairs to expedite the licensure process for the following individuals: an applicant that has served as an active duty member of the Armed Forces of the United States and was honorably discharged, an applicant that is an active duty member of a regular component of the Armed Forces of the United States enrolled in the United States Department of Defense Skill Bridge program, an applicant that is married to or in a domestic partnership or other legal union with an active duty member of the Armed Forces of the United States who is assigned to a duty station in this state under official active duty military orders, and an applicant that has been admitted to the United States as a refugee, has been granted asylum, or has a special immigrant visa. Additionally, current law also requires the medical board, the osteopathic medical board, the Board of Registered Nursing, and the physician assistant board to expedite the licensure process of an applicant who can demonstrate that they intend to provide abortions within the scope of practice of their license. So for the purposes of this bill would require each board within the Department of Consumer Affairs to prioritize applicants seeking licensure who are descendants of American slaves. This requirement would only become operative once the following two actions occur. Senate Bill 581 is enacted. And so Senate Bill 581 is another bill that is currently moving through the legislative process, so it is pending legislation. And it would establish a new state agency called the Bureau for Descendants of American Slavery. So that bill would first need to pass, enacting that new state department. And then the second action is that new state department, the Bureau for Descendants of American Slavery, would need to establish a certification process for the descendants of American slaves. And so the bill also has a provision that it would remain in effect for 4 years from the date on which its provisions become operative. So once those two actions happen, or until January 1st, 2032, whichever is earlier, and then be repealed. So just some additional context. Last year, the board considered a somewhat similar bill, AB 2862. And took a supportive amended position. The previous bill did not specify how eligibility for that prioritization would be granted. And so when the board had requested amendments, that was one of the main things that was requested, as well as a request for them to change the term prioritize to expedite so that it aligned with the current processes and procedures. Happy to answer any questions.
Thanks, Lori. You answered the main question, and that was the certification for me. Any other questions or comments from board members? Board Member Allison Cormack.
Thank you. Quickly, so it's, the Senate bill is 518 or 581? I think you've got 518 in here, but you said 581.
Oh, I did. My apologies.
No worries, no worries.
Thank you for catching that.
Still morning. Okay, and then it still seems important to me that the wording be changed from prioritize to expedite. So is the chair looking for motions or not yet? Oh, yeah, go ahead. No, go ahead.
Yeah, other comments from board members. Board Member Patricia Nguyen.
Well, you know, I support the intent of this bill very much. And I do love the phrase, this is one small step in righting the wrongs of the past. My concern is a 4-year window and there's, you know, an accompanying bill that has not been passed, that has not become law, that creates a department that will set up procedures, but it's going to take some time for that department to get up and the window just keeps shrinking. And it just feels like we're kind of cart before the horse. I'd love to see the department established, and then I'd love to see a bill like this passed, but I just worry about the timing.
So just to clarify, the law says either 4 years from the date the provisions go operative. So that's assuming the bill passes, the department is stood up, and the certification process is established, then the 4-year clock would start, or 2032, whichever comes first. So there is a time frame, you're 100% right, but it's a little bit longer. So it's assuming either we have until 2032 to give that buffer, or the clock starts 4 years after the process has been created.
I mean, certainly you can see that the race and ethnicity, you know, grid that you have here in terms of how many Black and non-Hispanic workers we have in healthcare is very underrepresented. So, and of course, slavery is part of the reality of kind of why these numbers are the way they are. So I'm inclined to support it, but I do kind of worry about the timing. But thank you for that explanation. That helps.
All right, any other questions or comments from board members? I would like to make a motion to support this bill. Do I have a second?
I second, Lawler.
Thank you, David. BRN moderator, can we please go out to public comment?
We will be opening for
I'm
public
so
comment.
sorry. Board Chair Chohi, excuse me. May I offer a friendly amendment before we go to public comment, or would you like to take that after public comment?
No, I can take it now.
Okay, I would just like to suggest that we support with amendments to change the word prioritize to expedite. That's consistent with our prior position, and then also with the way that we manage the licensure process.
All right, so moved.
Thank you so much.
BRN moderator, can you please take us out to public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comment. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Sandra would like to make a comment. 1 second, please. Sandra, on your computer, if you have Windows open, box is open, you have to look for it's a small box that says unmute me, and it's usually hiding behind open windows. There you go.
Public comment? So
Yes,
I'm
go
sorry
ahead.
where that confusion was at. Thank you.
Trouble with the audio. It was just a thing.
Board moderator, we're not able to hear the public comment.
Okay, are you able to hear me?
Yes, we
We
No.
can hear you now.
Okay, is it okay if I can do like a really quick comment about the last section that we were discussing? About the language and all that? I don't know if it's possible.
Yes, well, we could hear.
Okay. So I did my NCLEX. I graduated from Mexico, right? So I do believe if we translate, there is some words that for nursing are possible to do. Like we have a different program. So like if we did a test in a different language, it will be very, very challenging. I don't know like if I explain myself. Like when I did my studying for the nursing as a bachelor's here, I had a study topics because go and we also have a different ones over there. So that is just like a comment.
Thank you.
Thank you for your comment.
Yeah, thank you very much.
I'm gonna see here. Desiree, would you like to make a comment? 1 second, please. Oh, Desiree is not in my list, so she must have made her comment and left. Sorry. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any in-person requests for comments?
No requests for comments here.
Thank you. Would you like to close this window?
Yes, please. Thank you. All right, we're going to take it to a vote. Dolores Trujillo votes yes. Board Member Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member David Lawler.
Lawler, yes.
And Board Member Allison Cormack.
Cormac, yes.
Motion carries. Thank you.
Thank you. So the next bill is Assembly Bill 876. And this bill would amend the Nurse Anesthetist Act, which is housed under Article 7 of the California Nursing Practice Act. So there's a couple sections of it, and I'll kind of break it down one by one. The first is definitions. The bill would amend the current definition of nurse anesthetist by striking the phrase "a person" and replacing it with "a certified registered anesthetist, CRNA, nurse anesthesiologist, or anesthetist." Apologies. The bill would also add the following definitions. The term acute care facility, which would mean a general acute care hospital, acute care psychiatric hospital, or other setting that is licensed and accredited. Outpatient setting, which would mean an ambulatory surgery center, clinic, facility, office, or other setting that is licensed and accredited. And a dental office, which is the office of a dentist holding a permit pursuant to another section of the Business and Professions Code that falls under, I believe, the Dental Practice Act. Or actually, no, I correct myself, that is a different section, that's a cross-reference. So next section is anesthesia services. Current law states that utilization of a nurse anesthetist to provide anesthesia services in an acute care facility shall be approved by the acute care facility administration and the appropriate committee, and at the discretion of the physician, dentist, or podiatrist. It also states that if a general anesthetic agent is administered in a dental office, the dentist must have a permit as authorized under Chapter 4 of the Business and Professions Code, which is under the Dental Practice Act. Apologies, that's what I meant to reference. Excuse me, the bill would add the following provisions. In an acute care facility, outpatient setting, or dental office where the nurse anesthetist has been credentialed to provide anesthesia, the anesthesia services shall include preoperative, intraoperative, and postoperative care and pain management for patients receiving anesthesia requested by a physician, dentist, or podiatrist that are provided within the scope of practice of the nurse anesthetist. Next, it would state that a nurse anesthetist is authorized to provide direct and indirect patient care services, including the administration of medications and therapeutic agents necessary to implement a treatment for disease prevention or a rehabilitative regimen ordered by and within the scope of practice of a physician, dentist, podiatrist, or clinical psychologist. It would state that an order entered on the chart or medical record of a patient shall be the authorization for the nurse anesthetist to select the modality of anesthesia for the patient and to abort or modify the modality of anesthesia for the patient during the course of care. It would also state that ordering and administering controlled substances and other drugs preoperatively, intraoperatively, or postoperatively shall not constitute a prescription, as that term is defined under Title 21 of the Code of Federal Regulations. And these next provisions they were removed from the original analysis by accident by me. I missed them. The current analysis that is posted is accurate. In your Beanie materials, it is page 5, starting with the second bullet. And it lists some more information on the anesthesia services. So I just wanted to note that that was accidentally, I missed it in the first analysis. It is currently updated. I apologize. So the bill would, in an acute care facility, outpatient setting, or dental office where the nurse anesthetist has been credentialed to provide anesthesia, anesthesia services may also encompass services performed outside of the perioperative setting, including but not limited to selecting and administering medication, therapeutic treatment, medication-assisted treatment, and adjuvants to psychotherapy, providing emergency critical care and resuscitation services, performing advanced airway management, performing point-of-care testing, ordering, evaluating, and interpreting diagnostic laboratory and radiological studies, using and supervising the use of ultrasound, fluoroscopy, and other technologies for diagnosis and care delivery, providing sedation and pain management for palliative care in accordance with the policies of the facility or office, initiating orders to registered nurses and other appropriate staff as required to provide perioperative and postoperative care related to the anesthesia services, ordering consults, treatments, or services relating to the patient's care. And the bill would also state that to provide anesthesia services in an acute care facility, outpatient, or dental office, a trainee, including a nurse anesthesiology resident, registered nurse anesthetist, or student registered nurse anesthetist, shall satisfy both of the following requirements: be enrolled in an accredited doctoral program of nurse anesthesia, or practice under the supervision of a nurse anesthetist or physician anesthesiologist. Excuse me, I said or, but I meant and. It says shall satisfy both. And then last has a section related to scope of practice and supervision. Current law states that in an acute care facility, a nurse anesthetist is not an employee of the facility, who is not an employee of the facility shall nonetheless be subject to the bylaws of the facility and may be required by the facility to provide proof of current professional liability insurance coverage. A nurse anesthetist shall be responsible for their own professional conduct and may be held liable for those professional acts. This bill would add the following provisions related to the scope of practice and supervision. It would state that a nurse anesthetist is an advanced practice registered nurse who is authorized to perform independent anesthesia services and is not limited to the scope of practice of a registered nurse while performing anesthesia services. A nurse anesthetist shall also not be required to do any of the following: perform the duties of a perioperative registered nurse or nurse circulator while engaged in the role of anesthesia provider in the perioperative setting, perform nurse anesthesia services pursuant to standardized procedures, or perform anesthesia services under the supervision of the physician, podiatrist, or dentist who requested the anesthesia to be administered. And lastly, the bill will clarify that by virtue of being in the same location as a nurse anesthetist performing anesthesia services, a physician, podiatrist, dentist, or other healthcare provider shall not assume supervision of the nurse anesthetist. Apologies for those skip-ups. It is more technical, so I wanted to make sure to read it as directly as I could.
Thank you, Marissa.
So Neelu Patel, she is our advanced practice representative of the board. She's not able to be here today, but she is a certified registered nurse anesthetist, and she had sent me a letter that she wanted me to read to show her support. And so she says, Madam President, fellow board members, and esteemed attendees, although I cannot be present today, I want to express my support for AB 876 introduced by Assemblymember Flora. This bill is a significant step in ensuring clarity within the Nurse Practice Act regarding the role of CRNAs in California. This bill recognizes CRNAs' advanced education, training, and expertise in providing safe and high-quality care, anesthesia care. CRNAs have long provided safe anesthesia care across acute care facilities, outpatient settings, and dental offices, ensuring patient access, especially in our 4 rural counties where CRNAs are the sole anesthesia providers. AB 876 reinforces the CRNA's role in anesthesia care in California. It preserves efficient, cost-effective, and accessible services while maintaining appropriate oversight through credentialing. This bill does not expand scope, but rather clarifies the essential role CRNAs already fulfill in California's healthcare system. I appreciate the board's thoughtful consideration of this legislation, which helps protect patient access to critical anesthesia services. While I regret not being here today, I trust in your deliberation and look forward to our continued work together. Thank you. Neelu Patel, DNAP, CRNA, FAANA.
Thank you, Lori. Any questions or comments from board members? David Lawler.
To start with, I support this. But as a ignorant public member, I read it going, but isn't that what they already do? That's that's what they do. So why is it necessary? I love the clarity. I love the way it's written. It's obviously done well. But isn't this what they already do?
It is what they already do here in California. The issue that has been raised on several occasions is we have very limited statutory language around nurse anesthetist practice and care, and we have no regulatory language. And because of that, there has been several interpretations out there, depending on who is doing that interpretation on what can and cannot be done by a nurse anesthetist. Previously, going back to what I've been able to at least find from early 80s, where the board's executive officer at that point had sent out letters clarifying nurse anesthetist practice. Another letter went out in 1988, another one in 1990, all by the board's executive officers. And then I believe another one in like 2010. There was an issue that occurred during a review at a surgical center this last, I believe, a year and a half, 2 years ago, where their practice was questioned again. They reached out to me to send that same letter. I agreed to do that. And then upon legal review, it was determined that that was not something that we could do further. So now it's how do we fix this so we never run into that issue again? And so we did start the process with the Nurse Anesthetist Advisory Committee that we have to draft regulations. During that process of trying to draft regulations, it was difficult tying it back to specific areas in the statute because our statute's very limited. And so upon discussions, there were some discussions with the various organizations and people that support CRNA practice out there saying that legislation may be needed. And so they did pursue legislation, and this is where we're at today. And it essentially is exactly what you thought, to codify what is currently happening in California so that there's no other misinterpretation or question going forward.
Board Member Patricia Nguyen.
Thanks very much. Yeah, so I've read the analysis and certainly see how much support we have for this bill. And I think that this is a good idea also. But Marissa, maybe you could just help me on page 6 of your analysis. There's just two bullet points that I just had a question about. And one is a nurse anesthetist shall not be required to do any of the following. And one of them is perform anesthesia services under the supervision of a physician, podiatrist, or dentist who requested the anesthesia. So is that just to clarify that it's an independent practice and one isn't above the other?
Right.
Okay.
Yeah. So, it's already been kind of ruled in the courts that they aren't, law does not require them to be supervised when
Okay.
they're administering the anesthesia. In terms of whether or not we can, facilities at the end of the day, we don't have control over.
Right.
So there are provisions they can take to put it in place, but it's not something that has to be required. They have the authority to administer those services sans supervision. And that's
So
what-
the second bullet is kind of the same by virtue of being in the same location as a nurse anesthetist performing anesthesia services, a physician, podiatrist, dentist, or other health care provider shall not assume supervision of the nurse anesthetist. So again, it just seems like you got a dental practice, you have a nurse anesthetist, you're doing a procedure, you know, you got a patient, and that just kind of was like, shall not assume supervision. I just didn't understand how that could.
I think, and I'll let Lori jump on as well, but I think it's more to clarify that there's not kind of a default there, especially when you
Okay.
have someone who maybe is a surgeon, right? And then you have a CRNA. The surgeon expertise is not going to be in anesthesia. So they may be concerns that there is, you know, they're now taking on supervision and so I think it's just to clarify that that CRNA has their own kind of authority in operating.
Thank you. That's fair.
Yeah.
Didn't I just say ditto to that?
Okay.
There's nothing we need to do. Yeah.
Okay, Board Member Allison Cormack.
Thank you, Chair Trujillo. I want to thank the advisory committee. I'm grateful for the service of our colleague, Vice President Neelu Patel, and information from the association. So I think we've all learned a lot over the past year plus about this topic. And I am supportive, and I do have two things I just want to discuss a little bit, just for, understanding. So the part that says that ordering and administering controlled substances shall not constitute a prescription, the average layperson is like, how does that work? So I just like, us to understand a little bit about that. And then I see that in a related bullet, it says that, anesthesia, the nurse anesthetist may select and administer medication. So, I used to work in tax policy, and there were a lot of words you could use that weren't taxes. So can we just talk a little bit about, just so we're all super clear, about what ordering and administering, why that's not a prescription, just so we understand, and how ordering is different from selecting. Administering makes sense to me, and I understand someone has to choose the appropriate, drug or combination of drugs, but can we just get a little more clarity on prescriptions, orders, and selecting?
Yes, and again, we'll take a stab and I'll let Lori help. Because also as a layperson, I had that same question. And my understanding is that it's trying to delineate between ordering some type of medicine for the purposes of the anesthesia services that are being delivered. So that pre, during, and post versus a kind of standard prescription we think of. You go to a pharmacy, you pick it up, you take it home. So it's within those, the pre, during, and post is that they have the ability to kind of choose the appropriate medications for that patient based on that patient's physiological response, right? Because when we go under anesthesia, no one knows how, everyone reacts differently. So it's the ability to kind of choose based on the patient, which would be different than saying, writing a prescription for you to grab at Walgreens later on. And I believe it's trying to kind of make some clarity there, but please correct me if I'm wrong, Lori.
Okay, and we don't have a word for that, which is different from prescription.
We don't.
Okay.
So prescriptions fall under pharmacy law, and there are several regulations that follow under it. The current practice that is done is they do select and order, select and administer the medication that when they're in anesthesia, they'll titrate to a specific level of consciousness, or they'll notice that the patient's blood pressure is increasing and the heart rate's increasing, and so they might be experiencing some pain, and so then they can deliver some medication. current nursing practices administer, which is why that's very easy to understand. And in their advanced practice role, they will select those medications during the anesthesia time period. And so as with our other two advanced practice nurses, the midwife and the nurse practitioner, they have prescribing abilities, and that's done through their furnishing license.
Right.
A nurse anesthetist does not have prescribing abilities through the furnishing license. And so this is a path forward for them to ensure that if and when this, I'm going to be positive here, if and when this passes, that they will be able to select those medications for the specific time period that's delineated in the bill to provide those. Now, the other question that you asked about was with the Schedule II kind of drugs and such. And so currently CRNAs utilize the hospital's DEA license in order to have that process.
Great. That's super helpful. And I think it can be confusing to, like, there's prescriptions, there's furnishing, and now there's selecting and administering. So that's fine. We got 3 different categories. Got it. More than 3. I'm going to have to write them all down. And then the other question I have, and again, this is probably already current practice, but it was just not something I was aware of before, was in the acute care facility, the part on page 5 in the middle, towards the end of all of those bullets, it says, in accordance with the policies of the facility or office, initiating orders to register nurses and other appropriate staff. And I just noted that. And is that also something that just currently occurs? And so it's not a change in hierarchy or anything like that?
Yeah, it does currently occur. I actually worked as a circulator and a recovery nurse as well, underneath nurse anesthetist in my prior lifetime. And in Business Professions Code 2725, it delineates out podiatrist, dentist, psychologist, physician, surgeon. It doesn't say nurse anesthetist.
Right.
And so this really does allow for that to continue with this clarification.
Great. So with that, certainly just want to take a moment to say that, how important this role is. And, any of us who's had anesthesia or watched a family member who was suffering be helped, anyone who knows that it's the nurse anesthetist or anesthesiologist who cares for the person as a person when they are anesthetized, this is an incredibly important role. And reading the history of how many decades this has been going on, I'm very glad to see that the groups of people have come forward to say, let's get this down where it needs to be and move back to helping patients in pain. Thank you.
Any other questions or comments from board members? All right. I would like to make a motion to support this bill. Do I have a second?
I'll second
Yeah,
it.
go ahead.
Everybody
Thank you,
seconds
Patricia
it.
Nguyen. BR moderator, can you please open this up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, I would like to make a comment. Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Joshua Kemper would like to make a comment. 1 second, please.
Hi, Joshua Kemper, nurse anesthetist in the Central Valley, commenting again. Thank you so much for the excellent review of the issues surrounding the need for this Assembly bill. I'd just like to continue along those same lines. This is highly targeted to address certain regulatory overreach. In this case, I believe the California Department of Public Health imposing unnecessary restrictions and kind of sowing discontent and uneasiness amongst hospital administrators and surgeons because of the lack of clear statutory language. It's not changing anything about the way we actually practice right now, but just making it crystal clear exactly how CRNAs practice in California right now. Thank you again, and I urge your support for Assembly Bill 876. Thank you.
Thank you for your comment. Elizabeth Bamgoes would like to make a comment. Bamgoes. Sorry, Elizabeth. There you go.
First, just wanted to thank the board for the time that you've invested in getting to know a bit more about our practice over this past year plus. I'm completely humbled by the comments today and your deeper understanding of where we're coming from and the practice that we carry out every day in California, but as mentioned just prior, that we've been carrying out for greater than 150 years across the nation. So thank you to you all. I also just wanted to reiterate that having practiced 18 plus years myself and doing, of course, thousands and thousands of cases, and now both practicing and as a full-time educator to the profession, that the degree of rigor that our education holds across the nation and, of course, in all 5, now 6 of our California schools is commensurate with the level of work and care that we are able to provide to every California patient who we interact with. And I think this bill does nothing except to reaffirm what we are doing out there every day and what we are educating the future to do, and then allowing for the many administrators who help us to credential and work within their facilities with their clients and patients to make sure that we're all on the same page and understanding what our role is in a patient's surgical journey and anesthesia journey. So with that being said, just again, appreciate the support and the time invested into helping us to reaffirm this and make this very well articulated within the language that the BRN holds for us. Thank you.
Thank you for your comment. Julia Harris would like to make a comment. Second, please.
Thank you. Thank you very much. Good morning, members of the Board of Registered Nursing. My name is Julia Harris, and I urge your support for AB 876, a bill that protects the public safety and access to anesthesia care by clarifying the role of nurse anesthesiologists in California. This bill ensures that patients receive safe, timely, and uninterrupted anesthesia services by preventing unnecessary restrictions on nurse anesthesiologists' scope of practice. Nurse anesthesiologists are highly trained anesthesia providers. Liz has gone into the extensive training that we've had. We deliver anesthesia independently across hospitals, surgery centers, and critical care settings, ensuring safe and effective anesthesia care. Despite our proven track record, misrepresentation of Nurse Anesthetists Act has been exploited to change nurse anesthesiologists, or to challenge nurse anesthesiologists' ability to practice, creating barriers that delay and deny patient care. These actions do not only restrict access to anesthesia, but also jeopardize patient safety, particularly in rural and underserved communities, where nurse anesthesiologists often are the only anesthesia providers. AB 876 prevents these unnecessary disruptions by reaffirming that nurse anesthesiologists can administer anesthesia independently and clarifies that our role extends across the full continuum of anesthesia care, from preoperative assessment to postoperative recovery. This bill protects patients by eliminating legal uncertainty, ensures anesthesia services remain available, and allowing hospitals to utilize nurse anesthesiologists effectively to meet patients' needs. Without AB 876, facilities may face increased surgical delays, staffing shortages, and reduced anesthesia availability, ultimately putting patients' lives at risk. By supporting AB 876, the Board of Registered Nursing can help ensure that all Californians, regardless of location, have access to safe, high-quality anesthesia care without unnecessary restrictions. I respectfully urge your support for this critical bill. Thank you.
Thank you for your comment.
Board moderator, before we move to the next comment, I just want to make sure that the public commenters are aware that the board did take a position of support. And so when you guys were saying we urged the support, I just want to let you know that it was supported so that there's no clarification needed.
Dr. Kristen Roman would like to make a comment. 1 second, please.
Hi, this is Kristen Roman. I want to say thank you first and foremost for the support of the board. I do practice in an ACT full supervision model at a large hospital in Los Angeles. I also practice independently with no physician oversight at a number of surgery centers in the greater Los Angeles area. I provide over 2,500 anesthetics annually. I just want to emphasize that special interest groups have purposely exploited the language in the Nurse Anesthesia Act to challenge the right of CRNAs to practice in California, that interpretations of the Nurse Anesthesia Act and a seemingly willful ignorance of CRNA practice as legally established time and again throughout the past 40 years has become weaponized to threaten the closure of healthcare facilities when CRNAs practice to their full and lawful scope. Over 1,000 cases, primarily of Medicare and Medi-Cal recipients, were canceled when the CDPH survey team, led by a physician anesthesiologist, misinterpreted CRNA practice. The ramifications of this action have been felt throughout the state as public confidence in CRNAs has eroded. At my hospital in Los Angeles, I've been personally affected as the ability of CRNAs to safely train our own nurse anesthesia residents is being called into question and challenged. I do appreciate your support, and I urge you to continue to support AB 876, as this bill is essential to safeguard patient access to anesthesia care by codifying and clarifying existing CRNA practice. Thank you so much for your time.
Thank you for your comment. Kevin Valentine would like to make a comment. 1 second, please.
Members of the board, my name is Kevin Valentine, and I'm a student registered nurse anesthetist at Samuel Merritt University in Oakland, California. I just wanted to attest to Dr. Bambouche when she stated the rigors of nurse anesthesia school. And I can attest through these rigors through my blood, sweat, and many, many tears. And I just want to thank you for supporting AB 876 because it ensures that the rigorous education I'm currently enduring will be preserved upon graduation. So again, I thank you for your time, support, and commitment. Thank you.
Thank you for your comment. Deborah Barella would like to make a comment. 1 second, please.
Hi, Deborah Varela, CRNA. First, I would absolutely like to thank the board for not only the support that we're hearing, but more importantly, just evidence of the work that you put into fully understanding the bills and all that goes behind it. I've been a nurse, an RN for 40 years, a CRNA for 34 years. And I personally have always felt very supported by the Board of Nursing. And again, thank you. Of my 34 years as a CRNA, 28 years of it has been in CRNA only practice. 4 of those years were abroad in the 67th Combat Support Hospital, and then the other years spent in rural facilities. As I mentioned earlier, I'm currently employed in the Central Valley, the hospitals that were impacted this past summer. All of that has been explained well, and again, I appreciate your support. But as you know, at the heart of all the things that you do and that we do as nurses is patient care. One impact of this, aside from things we've discussed, such as difficulty recruiting or facility hesitation using CRNAs due to the events that occurred, something that is difficult for me after 34 years to see is that this has resulted in perhaps mental anguish for our patients, seeds of doubt placed in professionals that they've relied on, you know, all their lives for themselves and their loved ones. Now, do we talk them down? Absolutely. I'm always happy to talk about what I do and how I came to do it. Again, we're 100% board certified, and it's not a difficult profession to support. But I just wanted to express my gratefulness and appreciation that this could help clarify and alleviate patients of concern when they're already worried about surgery. So thank you again. I appreciate all your work.
Thank you for your comment. We had John Williams who wanted to comment, but he has dropped off. Gina Yan would like to make a comment. 1 second, please. Gina, on your phone, it's either *6 or #6. There you go.
Thank you, moderator. I think I got it to work this time. Thank you,
Thank you.
members of the board. I know I've already spoken on the issue, but I truly appreciate your support on this matter. And I would really like to tell you a little bit about my anesthesia group that I'm currently practicing with. Like I said, I am a resident of Bakersfield, California, and our anesthesia group consists of about 25 CRNAs and 4 anesthesiologists. And in the last year, we provided about 6,000 anesthetics and 2,000 obstetric anesthetics, and that is sole CRNA practice. In addition, we provide preoperative assessment, as well as ordering certain tests, such as laboratory exams, EKGs, in case that during their pre-op screening with the surgeon's office, something that's missed, that's something that is necessary for anesthetic care. We place orders for those. We also perform regional anesthesia, such as peripheral nerve blocks in the preoperative, intraoperative, and postoperative setting, as well as in the ICU for trauma patients that require pain management. We do airway management for the entire hospital outside of the emergency room, such as intubation that's required in the ICU. We also provide emergency anesthesia assistance to procedural areas, such as endoscopy suites, cath lab, when RTs and cold boost arises, and our obstetric services, epidurals and C-sections are provided by CRNAs. I am a relatively new provider. I graduated last year from Kaiser Permanente's anesthesia program. The reason why I relocated from Los Angeles, which has been my home for the last 25 years, to Bakersfield is because of the incredible group of CRNAs that I work with. I rotated there as a student, and I was truly wowed by their knowledge, expertise, compassion, and just the overall care they provide to these very, very vulnerable patient populations. And that is why I decided to relocate my entire life to work there. And I truly believe that this bill is a step in the right direction in clarifying the language in Nurse Practice Act in order to provide protection to these CRNAs and support their practice and all the good work they've done for these vulnerable patient populations, as well as protecting their access to anesthesia care. Thank you so much.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any in-person requests for comments there in BRNHQ?
Yes, we do. We have 2.
Thank you.
Probably
3.
Yeah. And then before we go to the public comment here in person, John Williams had dropped off. He did type a comment in here, and it says, I have worked as a nurse anesthetist for 9 years, primarily in the underserved Central Valley. I strongly support this in order to increase healthcare access, quality, and equity.
Okay, first.
Screen. Hello, my name is Melanie Rowe. I am a CRNA here. I'm in California and also the practice director for the California Association of Nurse Anesthesiology. Thank you so much to my colleagues who made comments, and thank you to the board as well. Very, you could tell I'm a little emotional, just very appreciative of the work that we've done in the last couple of years, and you guys have definitely heard us, so thank you so much. Just want to address Board Member Cormack's questions, and I think that this definitely exemplifies why this bill is so necessary, because over the years, we have continued to try and explain the difference between a prescription and order and select and administer. And so because our Nurse Practice Act has a word order, but then there's a Code of Federal Regulations part that I'm going to email to Ms. Clark. Part 1300, a prescription means an order for medication which is dispensed to or for an ultimate user, but does not include an order for medication which is dispensed for immediate administration to the ultimate user. And so in anesthesia administration, that's what we're doing every day. And also the select and administer wording is used in many other statutes of other states, but it's also our scope of practice language from the American Association of Anesthesiology and the accreditation COA that accredits all of our schools and how we are educated as CRNAs. That is the same language to select and administer. So all the pharmacology classes we take, 2 semesters of pharmacology just in CRNA education on top of our RN pharmacology education is how we have the knowledge and the experience to be able to select those medications. And then our nursing experience is how we deliver and administer those medications on a daily basis. And also, as you remember, with our previous attempts at being able to provide more anesthesia in dental offices, the confusion was completely about the difference between an order, the dentist ordering the anesthesia versus the dentist ordering medications to use in their offices. So this is exactly what we were trying to solve in this situation for this bill. So thank you very much.
Can you repeat the Code of Regulations that you referenced?
Yeah, 1300.
Thank you.
And it's a federal regulations on definitions.
Yeah.
Hello again, Emily Frank, once again, for the California Association of Nurse Anesthesiology. I'm the current president. I'm a practicing CRNA as well. And I want to reiterate, I had a whole statement ready, but I'm not going to bore you with all the details because you all seem to get it. And I want to start by thanking you all for that. I know it's been a lot of hard work, a lot of time and effort has been put into understanding what our practice is, which is kind of why we're here. It's kind of why we have this bill in the first place. It is difficult to understand in part because it is so piecemeal. It's all over the place. And so this is our attempt to put it in one place, make it really clear, and then build regulations on that in that order, because that's how things have to go, right? So I want to go back by supporting what our previous president, several presidents ago, Liz Bamboget had already mentioned. And I forgive not being able to pronounce her last name because we can't even say our own title most of the time. So it's fine. But this is not an expansion of scope. This is a clarification of our current scope and our current practice, as you stated. All of these things we do currently, which includes pre-oping patients and optimizing them for surgery, which means placing orders for X-rays, placing orders for EKGs, all those things to have other people carry out. So that is very much part of our normal practice currently. We want to avoid the misinterpretation, pardon me, and that things like the survey has caused all this ruckus in the Central Valley, and the chilling effect it's had, not only on what happened last year, but the chilling effect it's had on having CRNAs practice independently in these underserved and communities that just don't have the manpower to begin with. And we want to make sure that that we also emphasize, because we know what the dissenters will say, is that we have a shortage in California. So that's why we call this an access bill. This is truly an access bill. It's making sure that we can continue to work independently as we have and serve these areas that have no other providers in them. So there is no actual shortage of providers. We just see a common layering effect of multiple providers for one patient, which is the supervision model, which not only is kind of pointless, as we have lots of evidence to show, but is also extremely expensive, unjustly expensive, especially burden on these areas that are already burdened by hospital expenses. So we're trying to help with that. So I just want to make those 3 points, and I want to thank you again for all the time you've taken on these issues in the past and in the future. And have a good day.
Good morning, board. My name is Danny Bell. I'm a practicing CRNA and an educator at Samuel Merritt University. And as most educators know, we always like to get the last word. So I'm grateful for maybe being able to get the last word today. So I was a pediatric ICU nurse for 4 years, and in my practice as a nurse anesthetist, one common denominator is that uncertainty harms patients. That a lot of our work is to try to make the uncertain certain, and then we can care for the patients better. And as true as that is in clinical practice, that's true in regulatory practice as well. And so another thing, as an educator, I like to bring receipts. I like to bring evidence to everything I say. And so while I believe that there is uncertainty within the state of California, I don't believe that's BRN has done its job. BRN has done its job over and over and over again. The BRN has sent letters going back to September 12th, 1988, July 11th, 2002, January 24th, 2003, November 23rd, 2004, January 20th, 2005, emphasizing over and over and over again that CRNAs can practice independently. In addition to the BRN's good work, the state of California, through their court system, has also established that. Going back to 1984, there was an attorney general opinion to the California courts in September 28, 2010, an appellate court in March 15th, 2012, and the California Supreme Court in June 13th, 2012, all reaffirmed that the CRNA scope of practice, as we have outlined in the current statute that we're proposing. The reason that all those letters had to be written, the reason all those things had to be taken to court, is because that there were other entities that had confusion, whether it was California Department of Public Health, whether it was DHS, whether it's JCO or other entities and organizations, they all try to challenge or were upset or confused about what our scope of practice is. And so every single one of those times was a clarification of what we already have been established. And I've, again, like I said, very grateful for the California Supreme Court and for the BRN and all the work they've done to clarify that over and over again. The unfortunate part is every single time that that happens, that can cause a delay, that uncertainty can cause a delay to patient care. Like we saw recently in Doctors Hospital in Modesto, where thousands of cases were canceled and care was delayed. And so that uncertainty is really what we're trying to solve here, is to say once and for all what the BRN has already said, what the California Supreme Court has already said, what the Attorney General has already said, to say once and for all, put in stone, we're no longer going to tolerate any more uncertainty. This is exactly what the scope of practice is in the state of California. And we believe, California Association of Nurse Anesthesiologists, that by providing that clarity, by being more certain that that will provide more reliable access to care and decrease the kind of patient harm that happens when we have delays because of that uncertainty. As an educator, I can always go overtime, and so I'm not used to having somebody say stop. So
Is that your academic freedom?
Right. My students don't get to tell me that, but thank you for your time, all 2 minutes of it.
Thank you for your comment. Do we have any more? We have no more.
No more here at HQ.
Perfect. Thank you. It looks like Ashley Banks commented. 1 second. Let me see if I can get Ashley to come on here. Ashley Banks, if you'd like to make it. There you go. Go for it.
Hi. Good afternoon this time. My name is Ashley Banks, and I'm a critical care nurse, and I'm a current nurse anesthesia resident. I can make a verbal comment now. I wanted to sincerely thank you all, thank the board for your support of AB 876. As a current resident in the Central Valley, I'm just so grateful for your commitment to protecting CRNA autonomy and ensuring that nurse anesthesia providers can continue to deliver safe and high quality care without any unnecessary barriers. Thank you so much.
Thank you for your comment. Board President Trujillo, there are no other comments on the WebEx. We have no in-person requests for comments there in BRNHQ.
No further in-person requests for comment here.
Thank you. Would you like me to close this window?
Yes, please. Thank you. All right, we'll take it to, we have a motion and a second on the floor. We'll take it to a vote. Dolores Trujillo votes yes. Board Member Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen,
Win, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Allison Cormack.
Cormac, yes.
All right, motion carries. At this time, we will be taking a 15-minute break. Let's see, coming back at 12:15
Yeah, thank you. So it's a little longer than
or
15 minutes,
1:15.
but that's okay.
1:15. Thank you.
Thank you, guys.
Welcome back. Moving on to the next agenda item. Next bill.
Yes. So the next bill is Assembly Bill
Chair
9.
Trujillo, I'm so sorry. I wonder if we should reestablish quorum.
Thank you, Allison. We should. All right, we'll take a roll call to establish quorum, reestablish quorum. My name is Dolores Trujillo, present. Jovita Dominguez.
Jovita Dominguez present.
Board Member Patricia Nguyen.
Nguyen, present.
Board Member David Lawler.
All are present.
And Board Member Allison Cormack.
Cormack present.
Thank you. Quorum has been established, and we'll move on to the next bill.
Thank you. So Assembly Bill 938. Just some background on what the current law is. In 2016, passage of Senate Bill 823 added Penal Code Section 236.14 to the law. And that section requires courts to consider upon a petition for relief, whether to vacate arrests and convictions that were the direct result of a person arrested or convicted being a victim of human trafficking. Then later in 2021, passage of Assembly Bill 124 added Penal Code Section 236.15 to the code. And that requires courts to consider, again, upon a petition for relief, whether to vacate arrests or convictions that were the direct result of the person arrested or convicted being a victim of intimate partner violence or sexual violence. So if the court grants a petition under either of these penal code sections, the conviction is then dismissed and deemed to have never occurred, which additionally means that the records of the crime are then sealed, destroyed, and are not distributed to licensing boards. So under current law, only individuals convicted of non-violent offenses can currently petition the court to vacate their conviction under the provisions either of Penal Code Section 236.14 or 236.15. So the bill before you proposes to make a variety of changes to the penal code in both of those sections. But there's one kind of main change that we wanted to bring your attention to, and that is that the bill would amend current law to allow an individual convicted of any offense rather than just a nonviolent offense to petition the court to vacate their conviction under the provisions of Penal Code Section 236.15 or 236.14 by establishing that their arrest or conviction was a result of being a victim of human trafficking, intimate partner violence, or sexual violence. So as is currently the practice, if the courts were to grant a petition under either of these sections, the records of the crime would then be sealed, destroyed, and could not be distributed to licensing boards. And so we brought it forward because there was a little bit of an overlap with another bill we discussed at our last meeting, AB 479. And that is a piece of legislation the board put forward that would require licensees who petition for relief under Penal Code Section 236.14, so due to intimate partner violence or sexual violence, to also serve that petition to the licensing board and allow the licensing board an opportunity to respond if the licensing board deems that that offense is substantially related to their practice as a licensee. Again, it doesn't change what the court's ultimate decision is. It just allows the boards to know kind of on the front end if they want to respond. So if this bill were to pass and 479 were to pass, then that petition notification requirement would go into place. And then the vacating options would extend to any offenses, not just nonviolent. However, if 479 were to not pass and this one were, it would extend it, but we wouldn't have that notification requirement. So there is kind of an overlap there. We just want to bring it to your attention for consideration and any questions.
Any questions or comments from board members? No? Board Member Allison Cormack.
So I do find it a little concerning that it would be also for a violent offense. I mean, there are a range of violent offenses, but I guess they didn't differentiate between misdemeanors and felonies in this, correct? No. Okay, so that's a bit of a concern. And then the softening of the language from direct result to result, I'm not quite sure why that would happen. If we felt strongly that the language from AB 479 should be incorporated into this, is that something we could do in a motion?
That is
or how should we reconcile the situation you described where this passes and AB 479 does not?
And that's a great question. It's one I've kind of been struggling with because it's tricky in that you know, you don't ultimately know the outcome of one bill and you can't have your kind of position being contingent. I believe you can request amendments in any form when you are suggesting them. So if you wanted them to be duplicative, I don't know if that's super common to occur, but I don't think there's anything prohibiting it, saying, you know, we would be okay as long as this safeguard is in place, which we're already also requesting in 479. That being said, they may or may not be open to those amendments. So I think you can pretty much request anything you want. I don't know if there's a guarantee it would, you know, go in, of course. And it is tricky, like you said, because depending on how the board feels about this bill, it could be like, okay, if this provision is in place, then we're okay with this provision. But if this provision isn't in place, then we're a little bit more concerned about this provision. So it is a tricky kind of place to be in. I 100% agree. And I've been grappling with that as well.
I guess the other thing is, you know, this is far outside our area, even assessing whether or not offenses should be removed from people's records. That's not really, you know, our lane, as it were.
Correct. And the only reason we brought it back was because of that licensing implication and because we did have that other bill. But also, to your point, if you feel it's not something that, you know, needs to be weighed in on, of course, totally up to your discretion. Just wanted to bring it to your attention.
I think it might be important for, you know, you to have the authority to have a conversation to explain the implication, but I look forward to hearing what my colleagues have to say.
Well, certainly I was concerned about the violent also, but you know, it's so hard to assess that without kind of taking in the totality of the circumstances. I mean, if someone really is being trafficked and they're being threatened and there's a violent offense and it's proven that they were being trafficked, you know, should that kind of prohibit somebody from kind of moving forward, you know, with the record? So I'm grappling with it also.
I'm not grappling with it because in the criminal study of, I'm making this up, but in the criminal study of victims of human trafficking, and even without, many crimes run the risk of having violence as a side effect or a negative consequence of the crime. If their owner has them breaking into a house, they might end up hurting someone or killing them accidentally in the process. So, which they'd never be in if they weren't a victim of abuse or trafficking. They wouldn't even be in a bad situation. I just know bad situations can turn worse. So that's why I can imagine a number of situations where I'm like, well, yeah, that could happen. So I have less of an issue. My only concern, or I should say, the only thing I catch is a loophole, because I love crime dramas, so I always look for the loopholes. If I can be exonerated of all violent crime as a victim of not human trafficking, let's say, but domestic abuse, did I just get permission to kill my abuser? That's the only loophole. I'm like, okay, so what happens when they kill their abuser?
Yeah, and I, you know, don't claim to be an expert on criminal law, but I think they would have to meet the letter of the evidence that is put forward for any of those three. That it was, as Board Member McCormack mentioned, the other thing this bill would also do is currently you have to provide clear and convincing evidence that that crime was a direct result of either human trafficking, sexual violence, or intimate partner violence. This bill does propose to remove the word direct, so potentially opening that up a little bit, but they are still expected to prove that that act was a result of what they were experiencing. So, right. Yeah.
And then again, just as a reminder, the only reason we brought this forward to the board is because of the bill that we're sponsoring, which is where in this part we're asking if the petitioner holds a license and the offense is substantially related to the qualifications, functions, and duties of a licensee, that the court shall consider and make findings regarding the impact on the public health, safety, and welfare and the evaluation pursuant to the subdivision, and also allows us to be noticed. we've been affected by this in our board where we did receive complaints. It was vacated. We had that information. We had to get rid of all that information and we were not able to pursue any kind of discipline against the license. And so, Allison, your thought about amending it to include that language from 479, I hadn't even thought about that before. It's a great idea. But that way, if 479 doesn't go through or it becomes a 2-year bill or something of that effect, it may be of benefit to add that as an amendment to this bill too. Because again, other than our bill being put forward right now to do this, this wouldn't have even brought in front of our board. That would have been something we would even have the discussion around.
I guess, how do we watch with amendments? That's not really a thing, right? I'm nervous about taking a support or oppose position, but I do feel that it would be appropriate for there to be an amendment that preserves the board's ability to discipline a licensee, or at least to provide information to the court that it would be important, for the board to continue to have that information, which would suggest not vacating the conviction.
Is that a
Sorry.
watch?
I don't think.
So are we looking at a motion to support if amended, and that amendment would be 479 being passed?
Well, I think we can suggest amendment without taking a position. I mean, I don't think you're forced to take a position, just to offer
Can we just recommend
constructive
an amendment?
So there's also something, and it's not as commonly used, but I used to use it when I was within departments, as neutral seeking amendments, where it's, your default is that you're neutral, however, you think the bill would be improved by this language.
I think given the not adjacency of the main topic to our work, I would be comfortable with that.
Is that a motion?
I'm looking at the chair if the chair would like.
I'm comfortable with that.
Okay, well, I'm happy to move that we adopt a neutral position with amendments incorporating the intent of AB 479.
I second that.
Okay, we have a first and a second. BRN moderator, can you please open it up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any requests for comments in person in BRN HQ?
There's no request for comment here in HQ.
Thank you. Would you like me to close this window?
Yes, please. Thank you.
Thank you.
All right, we have a first and a second on the floor. I'm going to take it to a vote. Dolores Trujillo votes yes. Board Member Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen.
Nguyen, yes.
Board Member David Lawler.
Lawler, yes.
And Board Member Allison Cormack.
Cormack, yes.
Thank you.
Thank you. So the next bill is Assembly Bill 985. So I'll just go through current law real quick. Current law states that a health care practitioner shall disclose while working his or her name and practitioner's license status on a name tag in at least 18-point type. A healthcare practitioner in a practice or an office whose license is predominantly displayed may opt to not wear a name tag. Current law states that if a healthcare practitioner or a licensed clinical social worker is working in a psychiatric setting or in a setting that is not licensed by the state, the employing entity or agency shall have the discretion to make an exception from the name tag requirement for individual safety or therapeutic concerns. use. And lastly, current law states that in the interest of public safety and consumer awareness, it shall be unlawful for any person to use the title nurse in reference to himself or herself and in any capacity except for an individual who is a registered nurse or a licensed vocational nurse as otherwise provided in section 2800. And this section does not prohibit a certified nurse assistant from using their title. I believe there was a typo in the analysis and that sentence got cut off, so I apologize. I'll just reiterate it. It states that this section does not prohibit a certified nurse assistant from using their title. So what this bill would do as of right now, it would further establish that it is unlawful for a person to use the title doctor or the letters or prefix DR on their name tag unless authorized to use that term pursuant to Business and Professions Code Section 2054 or any other law. So after the agenda was posted and we had this on there, I did learn from board staff that this is currently a spot bill. And so what a spot bill is, it's kind of a placeholder bill that members will typically introduce before a deadline because they have an intent to substantively amend it down the road, but they don't have the language at that time. You know, there's no legal requirement for them to amend it, but that's usually they're pretty upfront with that as their intent. And from what I've heard elsewhere, that sounds like that is the purpose of this bill, is that it's going to be changed down the road. It was already on there, so I did still want to leave it up to the board whether or not you wanted to weigh in on it in its current form or just, you know, take a pause right now and see what it ends up being amended into.
Go ahead, Tricia.
Marissa, if you weren't going out on, you know, maternity leave, I would say, let's just wait and see. But I think maybe it might be good just to have a preliminary conversation about it, just so, you know, you're involved and, you know, we hear your thoughts on it moving forward. I mean, I'm totally in favor of a bill that makes sure that patients are not confused or misled. But I think this kind of blanket, you can't use doctor even if you've earned a doctorate degree, kind of penalizes nurses in a way that other doctorates are not penalized. I mean, I have a doctorate, I don't use doctor, but some of my classmates do. And, you know, Dr. Biden calls herself Dr. Biden, and I don't think she shouldn't be allowed to. I don't think anybody thinks she's a physician. So, I mean, again, I'm kind of torn on this. I don't want to say that nurses are the only doctors that never get to call themselves doctors, but I would, of course, value the input from the nurses on our board just to see, you know, kind of what you think. And of course, the public members also.
Well,
Go ahead, David.
thank you. I was just going to say, obviously, totally, I defer to the nurses. I recall this conversation in past board meetings with neither, and the question was, can I, with my DNP, be called a doctor in a clinical setting? And even the professors with DNP say, please don't do that. I'm a doctor in the classroom. I'm a nurse. So, because the patient sees the white coat and thinks MD. And I don't know why that really matters. There's nuances. But if they think that, that could be an issue.
And if it helps just to clarify what, because there was, to your point, we discussed a similar provision last year in Senate Bill 1451. Those amendments ended up being codified into law. And so it did add some language to Business and Professions Code 2054, which is within the medical boards, that states you cannot use that term in a healthcare setting if it would lead a reasonable person to believe. And so what this bill would do is it would say you can't use that term on your name tag. So it is kind of tied, and there is an existing prohibition there, because one would think that their name tag would be in a healthcare setting, not necessarily, you know, but just to kind of clarify that it did end up passing, so that is current law, and this is adding another layer of it around name tags.
But in a healthcare setting, it would say Dr. Dolores Trujillo, nurse practitioner, right? And on the badge itself, it would say MD, or it says RN, or it says nurse. And a lot of times you have the badge that hangs, and then you have another section underneath here that just says nurse. Very plainly across the bottom. Same thing, it'll say doctor very plainly across the bottom, which is different. And that seems to be very clear when you're in a healthcare setting. I've never, and even, you know, looking at it differently since those bills and stuff were introduced, walked into a healthcare setting and there was not confusion by somebody saying Dr. So-and-so nurse practitioner on the badge. When they just, I've also been part of a practice where I did have a nurse practitioner that always introduced herself as Dr. So-and-so and was not clear. And that is problematic, especially when you're holding yourself out like that. That's a different thing. But on the badges, and Dolores, I don't know if you could talk about how even your badge at where you're employed, it has a separate section that very distinctly says nurse.
Yeah, we
So
have
that there
those. It's
is
another
not-
like card underneath your badge that hangs down below your card, the badge itself. It states either nurse, nurse leader, or MD,
Yep.
or, you know.
And that's a whole different, I think, safety part that was put on by the healthcare systems probably about 10 years ago, at least. And I think it came out through the Joint Commission. And so because that was addressed, because they didn't want that confusion. But what I hear from the nurses at various conferences and stakeholder meetings that I have is like, they worked very hard for that terminal degree, and they want that recognized. And I think there's a way to recognize it on the license and still be very, I mean, on the ID, and still be very clear that it doesn't mean that they're a physician.
Thank you, President Trujillo. Okay, so we're talking about name tags.
Correct.
Okay, and this could be in a hospital or somewhere else. This could be in a, okay. Do we have a sense of why the author introduced this bill? What is the problem that we're trying to solve here?
So that is how I learned it is a spot bill, because I had reached out to get some more information, a fact sheet, and that is when they indicated this is a spot bill. So there is an intent to substantively amend it down the road.
And when you say that, do you think it will still be in this vicinity, or do you think this is really a sort of gut and amend type thing?
It's hard to say for sure because I've seen both happen. I've seen it be in the exact same subject area, and I've seen it be in the same code, but a completely different topic area. So that is why it is kind of tricky, because we don't have, foresight into that. But yeah, I think this was typically they'll have an idea for a bill maybe in a kind of a general subject, and they'll be like, we don't have the language hammered out quite yet, but can we just make amends to X, Y, Z? And you'll see them kind of in different forms. Sometimes it'll be really clear, like it is the intent of the legislature to introduce.
Yes.
Other times you'll see them just kind of changing an and to an and comma, and you can tell it's a very, very, this one was a little bit more like, okay, you're adding a provision.
Mhm.
That being said, there's nothing to prohibit them, obviously, from putting this in and then gutting it kind of down the road. But unfortunately, I can't tell you exactly where it will go.
Okay.
Bill, would it be best, more prudent just to take no position right now?
So
We
it's
don't know what it's going to turn into.
Yeah, so it's totally up to you. And that is my best guess is it will change significantly. That being said, I can't guarantee that. There have been instances where there were bills that we were told or thought were spot bills, ended up moving kind of farther than we thought. And so we had to take positions down the road. That being said, that's not the normal occurrence. Typically, if someone says this is a spot bill, it usually is. But there's no rule that they have to.
Yeah,
Change it.
that did occur last year with us, where it was a spot bill. You guys took no position, and at the nth hour, it flipped. And because there was no position on it, I was like, Marissa, can we meet? Can we do anything? And she said, no. So we had to come back.
We ended up taking a position because it continued to move. in
Yeah,
its
we ended up
current
having to
form.
come back to get the position though first. So we weren't in the beginning conversations.
Well, as a spot bill, almost at the end of March, it's not going to go anywhere by May.
So again, you can't speak in definitivenesses, but in my experience, typically spot bills are going to be amended in your first policy committee.
Okay.
Not always. They can be amended later. Again, there's no hard and fast rule, but typically that will happen because it has given the author some more time to kind of flesh out the language. And then you want that policy committee to kind of weigh in on what that policy is. That being said, I have seen instances where they're amended not until the second house. And that's when you're kind of like, oh, wait, is this it? Or is there more coming? But most of the time I see them earlier in the process, but there's no guarantee that will happen. That being said, if you choose to take a position and then it gets amended, the position, that kind of would just cancel it out. And if it's still related to the work we do, it would come back in May. If not, then it wouldn't. So it's completely up to your comfort zone.
Can you remind us what our position was last year regarding?
On this subject area?
Yeah.
So with Senate Bill 1451 that had the provisions around that, there was a request to have those. So it was tricky because that was the same bill that had the AB 890 changes. So our request, and let me double check. I believe it was a support with amends. Because we supported the provisions, you supported the provisions around removing some of the requirements on AB 890, but there was a request to have the amendments around the use of the term doctor either removed or clarified to say that the person has to clearly identify themselves in that they could use doctor, but they had to indicate what their profession was with it. So I can pull up the position letter real quick if you just give me 1 second.
I remember, as she pulls it up, Nilu speaking about this last year because it affected her specifically, just what you had brought up, David, where in the school setting, she was Dr. Patel and she could not be Dr. Patel at the healthcare setting when she was doing clinicals. And so having that kind of issue with titling was something that I believe we did oppose by asking for that to be removed.
It was a support if amended.
Yeah.
So that we requested amendments around that provision of it. But with that type of position, if they're not made, it's a default to a neutral because the board did support the rest of the provisions around AB 890 and the access to the 103 and 104 certification, because it was that really big policy omnibus bill that had a bunch of things in it.
Anybody want to make a motion?
I know.
I think we should just. Or you can take no. No position.
Because if we change it, the position disappears, so.
Yeah.
I'd be willing to move that we adopt a watch position. Just keep an eye on this as it moves forward.
Cormac, I'll second.
All right, Biera and
Out of
moderate.
nervousness that something else will,
Yes. Biera and moderator, can you please open this up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any in-person requests for comments there in BRN HQ?
No, we don't have any requests for comments here in HQ.
Oh, somebody just jumped in. 1 second here. Valsala Zachariah would like to make a comment. 1 second, please. On your computer, if you have windows open, you need to minimize them to find the small window that says unmute me. There you go.
Center. Can you, as a RN, abbreviate your name in some way for safety reasons on your name tag?
Sure, that's. Not sure that's under the board's jurisdiction. It's the section being amended by this code that has to do with the. Yep. It is Business and Profession Code Section 680. 680? Yeah, the code states, except as otherwise provided in this section, a healthcare practitioner shall disclose while working their name and practitioner's license status as granted by this state on a name tag in at least 18-point type. So it doesn't speak to abbreviations, but it does state name.
So for the commenter, hopefully you heard that it took a moment. There is a business professions code section that speaks to the requirement of wearing a name tag and having your name on it as your name is reflected on your license with the BRN. So, and that's business professions code 680. My take on that would be that you cannot abbreviate because that's not how your name is reflected with the board. Thank you.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments. Would you like me to close this window?
Yes, please. Thank you.
Thank you.
I'm sorry. Let me take one more moment. Section 680A reads, if a healthcare practitioner or a licensed clinical social worker is working in a psychiatric setting or in a setting that is not licensed by the state, the employing entity or agency shall have the discretion to make an exception from the name tag requirement for individual safety or therapeutic concerns. And it goes on, but so there's that, I would call it a fairly narrow exception if you work in a type of facility that's not licensed by the state. Your typical ordinary hospital likely is licensed by the state. So that's something for you to look into. Look at this Business Professions Code Section 680, find out the type of facility that you work in, and follow up as to whether that applies to you. Thank you.
All right. We have a motion and a second on the floor. We'll take it to a vote. Dolores Trujillo votes yes. Board Member Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member Debbie Lawler.
Lawler, yes.
Board Member Allison Cormack.
Cormack, yes.
All right. Thank you.
Thank you. So the last bill is Assembly Bill 1082. Under current law, a student is allowed to render nursing services if those services are incidental to the course of study of one of the following: a student enrolled in a board-approved pre-licensure program or school of nursing, a nurse licensed in another state or country taking a board-approved continuing education course or a post-licensure course. So this bill would propose to amend that section to add an additional provision C that would state the following: a student who is a resident of the state and enrolled in a pre-licensure distance education nursing program based at an out-of-state private post-secondary educational institution for the purpose of gaining clinical experience in a clinical setting that meets all of the following criteria. The program is accredited by a programmatic accreditation entity recognized by the United States Department of Education. The board does not otherwise approve the program. The student placement does not impact any students already assigned to the agency or facility. The program does not make payments to any clinical agency or facility in exchange for clinical experience placements for students enrolled in a nursing program offered by or affiliated with the institution or private post-secondary school of nursing. And the program qualifies graduates for California licensure. So just some context, the board has considered similar bills the last 2 years and taken an opposed position. Kind of the two main concerns that had come up were related to program oversight and clinical impaction. In terms of program oversight, there is another kind of layer for you all to consider this year. that in lieu of board approval, the bill would require the program to be accredited by a programmatic accreditation entity that is recognized by the U.S. Department of Education. So they are charged with kind of overseeing the standards for accrediting agencies. However, as you may or may not know, the federal level, the president has signaled his plans to eliminate, abolish, dismantle. There's been different words used, so I don't want to overstate or understate it, but essentially make significant changes to the Department of Education, which could then eliminate their oversight of these accreditation entities. And so if that is removed, then there wouldn't necessarily be anyone in their place in the interim. And
And how many schools that intersect with California are accredited by the Department of Education presently?
So in terms of the number of nursing programs that currently have some type of programmatic accreditation, I would have to go back and double check. I believe it's around at the halfway mark. That's actually something I looked up around our faculty approval bill last year. Typically more of your kind of four-year institutions have that. More of your ADNs are getting it now these days. But I want to say it's at minimum 50%, but I could do a little bit of digging and get you a better number.
I wanted just an approximation. Thank you.
Yeah, but to clarify, they are accredited in addition to being approved. Okay. Yeah, so what this bill doesn't have any type of approval requirement, I think in its place is what it's suggesting is that accreditation. Currently, all states but 2 require nursing programs to have board approval from their board of nursing. There are 2 states that allow for accreditation to serve in the place of approval. So that is what this bill would do for these schools. Yep. And then just the note in terms of clinical compaction or impaction, which was another concern that has been raised in the past. We do know that the bill sponsor alone has thousands of California residents enrolled in this nursing programs. So that would be one out of, we're not quite sure, but a decent number of schools that would be eligible to have their students conduct clinicals in California without board approval. So that concern around clinical impaction is still live and well this year as it was in past years. And I did want to clarify or just give context that the bill does state that a clinical agency or facility cannot schedule a clinical experience placement with an out-of-state nursing program if the placement is needed to fulfill the clinical experience requirements of an in-state student enrolled in a board-approved nursing program. However, the board does not have jurisdiction over health facilities, so we would have no way to monitor compliance with that provision or in turn enforce compliance with that provision because it puts the burden on the facility. So happy to answer any other questions there may be.
And I'm just sharing my screen real quick here for you guys.
Oh, thank you.
NCSBN watches this. This is published as of 2019, so it is a few years old. But this is the NCLEX code approved programs. Those are board approved programs only. And then accredited programs are the ones that are either duly accredited or only accredited. So you can see the
PO
percentage
Melby,
there.
on the left-hand side, is that the test scores?
No.
It's just the number of programs? Okay.
Yes. Yep. NCLEX code approved means each one, and I'll stop sharing so we can clear this off. Each one of our applicants that apply to us enter a school code. That school code is what is transferred to with the student's information to NCSBN when we give an authorization to test. And so we have school codes that are granted by NCSBN by the Board of Registered Nursing on the various states saying we've reviewed them and approved them. And so then we reach out to NCSBN to get a school code for them. And that is additionally done. We'll notice that they're accredited or not. But as Marissa said, there's only 2 states in the nation right now that do not have the ability to approve in addition to the accreditations. And we do not require accreditation in our state, but we do require everybody to be approved.
I was able to find from last year, again, this was in 2024, there are around 86 of our programs, which was around 60%, were accredited by one of the main 3 nursing program accreditation in addition to having board approval.
And that's just our state. Yeah. And this includes the bill here is asking for all states. And it is different from state to state.
Correct.
how many are approved and not approved, which NCSBN's data that I showed there is a nationwide look.
Well, for all the reasons we've opposed this bill in the past, I suggest we oppose it. I move that we oppose it again this year.
I'll second that. David Lawler.
Okay, we have a motion and a second.
And then real quick before we go to public comment, I know that we write our letters based on specific items. And so you did say all the reasons as we did in the past. Are you wanting to additionally add the Department of Education and accreditation issues for this year so we can include that in the letter as well?
Yes.
May I just want to, one thing we haven't discussed yet is the difference between approval and accreditation and the focus on public protection. So, but translating the difference into something that is connected with our mission, I think is really where I am on this, in addition to all of the, the other issues. So I just want to be sure that's clear.
And then when Marissa was at hearing last year, defending or sharing our position, the statements that came from the California residents were they tried to go to community colleges. They tried to go to CSUs here in our state, and they couldn't get in. And that was due to clinical impaction. And then allowing for this to come forward just perpetuates that clinical impaction. And you would essentially end up with a system that you could never get students in California schools. Those schools potentially would decrease enrollment, stop enrollments, or close altogether. The sponsor of this bill, they had 3,000 students last year when we pulled the numbers. They have 5,000 California residents this year when we pulled the numbers. To put that into context, we only have 30,000 nursing students here in California. And that is a very large and growing number that is concerning for us. The other comments that we're receiving is kind of looking at our out-of-state approval process for our nurse practitioner programs. And that's an issue that's being brought up, saying that's an easier way. But this here would be an easier way as well. The out-of-state schools would have an easier way to get into California and approve over our in-state programs. Our in-state programs go through a much more rigorous review process and request approval from you guys to grow and expand. And that is not something that is required in this one. And so some of the discussions that, just looking at this is, what are the safeguards? How do we ensure that this, if something like this were to pass, how do we ensure that it doesn't negatively affect our programs and our students that are currently enrolled in it? And it truly just comes down to the same thing for me, is they need to be board approved. And our board needs to have authority over it to say, okay, I see this school, you're performing well. You can have 100 students in California, or you can have 200 students, however you want to do it. So we have some control. The other thing that we noticed with the sponsor of this bill is that their current NCLEX and pass rates and their placement rates and stuff, they would be a school in California that we would put on warning status with intent to close. Because they don't meet the same standards and their outcomes are not up to our approval standards, let alone an accreditation standard. And so that was kind of a concern when we were kind of going into this as to, what kind of authority would we have looking at this right now. And if we're deferring to accreditation and their pass rates for the last few years have been up and down, I think one of the years was above our threshold, but the other 2 years were grossly below our threshold in the 50s and 60s. And so what we've done in the past with our California approved schools is say, you need to stop enrollments. You need to stop enrollments and you need to work on fixing your pass rates. Because if you've got 100 students enrolled and you've got 50% pass rates, what are you doing to the 50% that are not passing? What kind of negative consumer effect is that? And we don't have any of that authority for this sponsor school or any school similarly like this.
Why would a facility take these students without any idea on how their coursework is or how their faculty is or how their simulations are going or anything?
So one of the things that I saw commonly when I worked in that realm was they were already employee of your hospital. So they might have been a CNA or a transporter or a phlebotomist or an LVN that's wanting to go back to school. They are a good employee. They go to this school, you want to help them out. You want them to become an RN. You want them to be employed in your hospital because you want to retain them. And so a lot of times you would make a contract to get that person that you have a relationship with through. And so that happened commonly. The other thing that maybe people are not aware of is that hospitals contract with academic institutions to do clinical practices, but they rely on the academic institution to let them know if something is not okay. So that doesn't always happen. And they're used to having relationships with the sister schools or the schools that are near them. They're familiar with them, but they would not be familiar with out-of-state institutions. And your education department, when healthcare fluctuates, one of the first lines to get cut is education out of there. And so they would not be monitoring that at a healthcare level either.
Board Member Allison Cormack.
Thank you, President Trujillo. I guess another thing we could contemplate including in the letter would be the number of nursing programs, the number of students we've approved in the past, say, 3 years, as an acknowledgement of the fact that, you know, there are more people who would like to be nurses than there are spaces for. And some of that's about, you know, qualifications, but some of that's about, you know, thoughtfully expanding. So that might be a data point to include, that it's not that we're unaware of the fact that it's difficult to get into an affordable nursing school.
Any other questions or comments from board members? I would like to make the motion to oppose. Oh, Tricia made it?
Yep. And
David seconded. Okay, thank you. BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Susan Engel would like to make a comment. 1 second, please.
With all the conversations going on, that the prior bill only addressed non-acute care settings. This bill includes all settings. So just want to point that out. Thank you very much, and great conversation.
Thank you for your comment. Board President Trujillo, there are no other public requests for comments on the WebEx. Do we have any in-person requests for comments there in BRN HQ?
No requests for comment here in HQ.
Thank you. Would you like me to close this window?
Yes, please. Thank you. Okay, we'll take it to a vote. Dolores Trujillo votes yes. Board Member Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen.
When, yes.
Board Member David Lawler,
Lawler, yes.
and Board Member Allison Cormack.
Cormac, yes.
Thank you. One more. Item 5.0, this is a discussion and possible action regarding proposed regulatory text to incorporate statutory changes from SB 1451, ASHB Chapter 481, statutes of 2024, and other related updates.
Thank you. So this is kind of tied to and building on a conversation that happened at the last board meeting. Just as a reminder, Senate Bill 1451 passed, making a lot of changes to the provisions for 103 and 104 NPs. And so we were making some changes to our regs to incorporate that, one of which was clarifying that they had to maintain their national certification, which was an existing requirement. We just wanted to make it clear. And a public commenter had made a good point that in how it was written, it was cross-referencing back to a section that didn't include legacy certification. So we tried to kind of do a quick amend on the spot to address that so that it wouldn't have to come back. And unfortunately, when I was incorporating that language, I realized while that was an accurate change, there was another spot that we would have had to include it. So I apologize, but since we had this meeting, we thought might as well address it. In discussing, we thought rather than, and this is just a kind of a preference suggestion to the board to consider, rather than clarifying both the 103 and the 104 section, that the national certification can include legacy and retired certifications, we are proposing to amend section 1481, which is what they cross-reference back to. So it would clarify in that section that you can get certification as a 103 or a 104 NP in one of the categories currently listed in 1481A, or in and I'll read the language exactly, a population-focused category whose exam was retired before January 1, 2017 by a national certifying body accredited by the National Commission for Certifying Agencies or the American Board of Nursing Specialties. So we just really want to make sure it's super clear that those are eligible because that was a strong effort in that bill. And so we want to make sure it's reflected accurately in our regulations. So I apologize. We didn't catch that when we tried to kind of do a quick fix last time.
Any questions or comments from board members? All right. I would like to make a motion to adopt the proposed regulatory text to incorporate statutory changes from SB 1451, ASHB Chapter 481, statutes of 2024, and other related updates. Direct staff to continue with the rulemaking, file and proceed with review by the Director of Department of Consumer Affairs and the Secretary of Business, Consumer Services, and Housing Agency. Upon their approvals, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all the steps necessary to complete the rulemaking and adopt the proposed regulatory text as noticed.
Cormac, second.
Thank you. BRN moderator, can you please open us up for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Board President Trujillo, there are no public requests for comments on the WebEx. Do we have any in-person requests for comments there in BRN HQ?
We do not have any requests for comment here in HQ.
Thank you. Would you like me to close this window?
Yes, please. Thank you. All right. We're going to take it to a vote. Dolores Trujillo votes yes. Board Member Jovita Dominguez.
Jovita Dominguez, yes.
Board Member Patricia Nguyen.
Win, yes.
Board Member David Lawler.
Lawler, yes.
And Board Member Allison Cormack.
Cormac, yes.
Thank you. At this time, this concludes our board meeting for today. Thank you for everyone's participation and hope you have a wonderful afternoon.